Hello, my name is Yoshi Bauer. Welcome to the My Special Needs Connection webinar and podcast series. As a parent of children with special needs and as a professional advocate, I understand the challenge of connecting parents and professionals with the information that they need to serve children and adults with special needs. At My Special Needs Connection, we empower parents and professionals through valuable instruction and insights of experts in the special needs community. We're excited to come alongside you to provide you with information that you need. Let's grow through the exchange of knowledge and the hope of success. Be sure to subscribe to our newsletter and YouTube channel for new releases. Please enjoy our webinars and podcasts.
I want to welcome you to this webinar entitled Update on Compensatory Education. I'm Thomas Nelson. I'm a special education attorney, and I presented a webinar with Yoshi Bauer a couple weeks ago on COVID-19 and distance learning, where we talked about a new standard for distance learning, including SB 98 and the Learning Continuity Plan. If you didn't get a chance to see that webinar, you can tune in at My Special Needs Connection and watch that. But one of the things that we talked about during that webinar was compensatory education, and focusing on whether during the school closure, which in California happened about mid-March, through the start of the school year just recently, is there any right to compensatory education if the child didn't get an appropriate program, a program that allowed them to progress or even not regress during that time period. At that point, there was very little information, very little case law, or I don't believe there was any hearing office decisions at that point, just even 2 weeks ago. But since we presented that webinar, there have been 3 cases from the Office of Administrative Hearings here in California that have, at least in part, addressed that issue. So what I'd like to do in this webinar is just give you an update on what those decisions held and where we might be going in terms of these hearing office decisions regarding compensatory education. And answering the question, basically, is the standard for compensatory education different? Is it any different because of the COVID closures? Does the law look at the standard for compensatory services in a different model because of the closures? Because the school districts obviously had much more difficulty in providing services. They were closed. And so did that affect the standard of proof when a parent seeks compensatory services because their child didn't get the services that he or she needed in order to progress? Well, there are only 3 cases, as I mentioned, so one might argue that that's not much to go by, but I think it's telling. I think the 3 decisions had very common rulings, common analysis of the law and the effect the law had on the COVID period. And so I think they can be very instructive moving forward as to what standard the Office of Administrative Hearings may be using for future cases. The good news for parents is, as I read these cases, is the standard for FAPE, or free appropriate public education, really hasn't changed much due to COVID. What we'll find in these cases is that the school districts, even though they were closed, still had an obligation to provide an appropriate alternative program or placement that, although maybe didn't follow the IEP that the child had in place before the COVID closures exactly, it materially followed that IEP. And that's the standard that we can glean from these 3 cases. So I'd like to start with just a slide on some of the authority that these decisions used in coming to the conclusions that they came to. The decisions mentioned U.S. Secretary of Education Betsy DeVos's statement that she was not recommending Congress pass any additional waiver authority concerning FAPE, or free appropriate public education, and least restrictive environment requirements of the IDEA, noting that learning must continue for all students during the COVID-19 national emergency. So that was obviously a very important point, because at the time people weren't really sure if she would be recommending a waiver of the IDEA, so kind of putting a temporary stop on the rights that children with disabilities would have during this period, but she recommended that it not be waived. So that's something that the cases mentioned and relied on. They also talked about OSERS, the Office of Special Education and Rehabilitative Services, and they issued a guideline that where there's been a delay in providing services because of the COVID closures, the IEP teams in the future must make individual determinations whether and to what extent compensatory services may be needed when schools resume normal operations. So in that guideline, essentially OSER said, we understand that schools may not be able to provide services that are timely because of the closures and trying to adjust to distance learning and all that involved, but that should be a topic discussed at an IEP meeting in the future regarding compensatory services. What may need to be done to make up for any loss, any time period where the child, for example, didn't get services. The decisions also mentioned the Department of Education in California, or the CDE, and they referenced their guideline, which said that the districts may consider alternative service delivery options, such as in-home service delivery, meeting with individual students at school sites or other appropriate locations to deliver services, that in some circumstances the districts or LEAs may need to provide in-person services for the student, and also encourage the districts to work collaboratively with non-public schools and agencies to ensure continuity of services. So in essence, they're saying that even if the school is closed and we can't have services at the school site, there may be alternative sites, including the home, where these in-person services might be provided. And even if, for example, district staff is not able to go into the home to provide these services, the districts are allowed to work with private organizations that are certified by the state of California to provide these kinds of services. And what we found in California is there are many private services that have been able to do this during COVID, that have been able to go into the home and provide these direct services to children. Finally, there was a decision out of the Ninth Circuit, ND versus Hawaii Department of Education, and they mentioned these, at least one of the cases, or I guess two of the cases mentioned this decision in this context. In ND, there was a school closure because of a fiscal crisis. And so the schools closed because there was basically a lack of money to support them. And so the court looked at, was this a change of placement? And the court said no, but in what's called dicta, it wasn't a direct issue in the case. They said, this failure to provide services during this closure really could be characterized as a material failure to implement the IEP. And so what you have here is a situation that at least two of the decisions that we're talking about said, this is analogous. During COVID, it really wasn't the district's fault that they had to close. And similarly, in this ND versus Hawaii, there was a fiscal problem. The schools had to close because of that. Really wasn't the district's own problem or fault in not providing the services. Their hands were somewhat tied. And the court, the hearing officers looked at this decision, even though it was what's called dicta, which isn't really binding authority, but it could be very persuasive, and said, in that decision, the courts looked at it and said, this could be a material failure of implementing the IEP, even though it wasn't the district's fault, even though they weren't really responsible for the fact that they weren't providing services. And the same is true here with COVID. They were basically ordered to shut down. But they still had an obligation to provide some alternative method of delivering services. So let's look quickly at each case, and I'm just going to highlight some of the main factors that happened. So the first one is Student versus LA Unified, and that was on Student versus LA Unified is the first case, and that was August 24th of 2020. And what happened in that case is that the student was a 22-year-old female. She was in the 12th grade. She had autism. She had intellectual delays. She was in a non-public school. She had deficits in social, emotional, adaptive behavior, communication, and academics, so pretty much across the board. During the shutdown and the distance learning, she got far less instruction during virtual learning than she had on her IEP. She really wasn't able to benefit from the virtual instruction. She needed, a person who could help guide her and be with her to make sure she was attending the instruction, and that really wasn't possible during the virtual instruction. And furthermore, she was unable to participate in community-based instruction that was critical to developing life skills and vocational training that was necessary for post-high school. And you can imagine the problems here. So she's transitioning on to post-high school, post an IEP. So what was really important for her was learning life skills, transition skills, so she could function as independently as possible in the adult world. And she needed community instruction for that. Showing her maybe how to, ride a bus or order food from a restaurant or buy a movie ticket, whatever those community life skills might be. How do you do that virtually? That's got to be very difficult. So she really didn't benefit at all during the virtual instruction on that very important part of her IEP. Well, it came to the decision. LA Unified basically argued, look, our hands were tied, we did the best we could, etc. But the hearing officer said, the standard for denial of FAPE during COVID is the same as it was before COVID, which is if there's a material failure to implement the IEP, something more than a minor deviation, then there's a denial of FAPE. There's a denial of that free, appropriate public education. And in this decision, they mentioned OSERS, and they said, that OSERS never stated that a district could provide FAPE simply by making great efforts or great strides. Trying hard, in other words, is not going to get you to that point of FAPE. They mentioned the CDE, that there was no waiver of FAPE. And they mentioned that both OSERS and CDE talked about if there is a denial of FAPE once school reopens, then the school districts can look at individualized decisions about whether the child needs compensatory services to make up for that loss. So the conclusion you get from this case is basically there really wasn't a change in the standard of denial of FAPE. If it's a material failure to implement the IEP, whatever they provided was not similar to what's in the IEP. There was more than a minor deviation. There was a material deviation, and that certainly happened in this situation. Then that's a denial of FAPE. And the way that schools are supposed to address this is through the issue of compensatory education. Because this child was, she's an adult, she was 22, she had aged out, so there really wasn't any IEP that could be called because she had aged out of special education. So the hearing officer awarded comp ed without an IEP meeting, and basically awarded some post high school vocational training to assist her in the life skills. Then we have another decision, and that is the student versus the Norris School District. That was decided on September 2nd in 2020. In this case, we have a 7-year-old first grader who has autism, speech-language needs, behavior needs. The child would elope, and also had academic needs. They, during the distance learning program, did not give this student the amount of academic instruction or speech that was on his IEP. The parent had trouble implementing the virtual instruction, wasn't sure how to use, the various packets that came home and how to provide that instruction, particularly in speech, to their son. The student was resistant to virtual instruction, especially speech, and there were problems with technology. So the virtual learning really didn't go very well, and the student didn't progress just minimally. The school district, Norris, argued, it's not possible to fully implement the IEP. We had the school closure and COVID, etc. But the hearing officer in this case ruled that even if a district can't fulfill the IEP exactly, it still must offer a temporary placement that closely approximates the IEP. So again, it gets back to that material implementation. It's got to provide an alternative to the IEP that materially implements the things that are in the IEP. So it doesn't have to be in the exact same setting. Obviously, schools are closed, so they couldn't provide those services in the school. But wherever they could provide them, including the home, it would have to be a very similar type of program with the services that the child received. In this case, the hearing officer reiterated there was no exception to COVID in the IDEA. There was no waiver. So even though the schools closed down, the takeaway was that the school districts must materially implement the IEP, even if it's through an alternative method of delivery. So there were a couple of procedural issues that were involved in this case as well. The hearing officer ruled that the district should have provided the parents with prior written notice due to the change in the method of delivery of instruction. I mean, obviously the IEP called for instruction in the classroom, but schools now were shut down, were closed, so the instruction was happening in the home. And so the hearing officer ruled that the district should have provided parents with prior written notice as to the reason for that change in delivery and alternatives and things they considered in making that decision. And the hearing officer, reiterated that this is especially true because the parents reported that the student resisted virtual learning and was not benefiting from virtual speech and language. So there was an additional reason to give parents this notice. They also said the district should have held an IEP even if it was done virtually. Again, they should have held an IEP to consider alternative methods of delivery, especially when they knew that the parent was reporting to them that it was not successful, that the student was resistant and they had problems with technology, that they had trouble providing the materials that were given to them by the school to the student. So based upon the prior written notice failure and the failure to hold an IEP, the hearing office ruled that the district significantly impeded the parent's opportunity to participate in the decision-making process. So there should have been that IEP to flesh all this out. What's working, what's not working, how to fix the problems that weren't working, And certainly the district was aware of these problems because the parents had brought it to their attention. So the order was basically to develop an appropriate alternative distance learning plan, one that met the essentials of the IEP, and they also awarded compensatory education. It went back before the COVID time period because there were some other problems that happened before schools closed. But this student got about 77 hours of compensatory academics, 40 hours of speech, 49 hours of behavior services, and about 19 hours of occupational therapy. So again, takeaway is, again, there's no exclusions, no exceptions. They have to materially implement the IEP, even if it's done in an alternative method of delivery. And there could also be procedural violations if the district failed to give prior written notice or call an IEP when they were aware of these problems. Now the final case is Student versus Pleasanton, and that was a stay put place. So the student had filed to try to get an order that the previous IEP should be stay put, in other words, should be implemented by the district. And basically the dispute was around in-person services. So this student had in-person services, quite a few needs: speech needs, occupational therapy, physical therapy, vision services. The student had a nurse who was a one-on-one aide. And in the distance learning program that started when school shut down, those in-person services weren't being offered. It was basically a virtual program without those in-person services. And the argument of the school district was, we can't offer in-person services due to the shutdown from COVID. But the judge in that case granted the stay put, and basically saying you do have to provide in-person services. And what the judge focused on was, first of all, the CDE. The CDE had issued guidance that schools are not prohibited from providing in-person services. Again, looking back to that first slide, they can do it through non-public agencies, private agencies that are certified by the state of California. And in fact, in this case, the district was providing some physical therapy in person due to a previous dispute that the student had had, and those were compensatory services. So the hearing officer referenced that too and said, well, wait a minute, you're saying you can't do it. Well, you already are doing it pursuant to a previous order. So the judge basically said, no, there's no prohibition from providing in-person services. And the judge looked at the distance learning plan and said, it's just not comparable. Due to the student's need for intensive services, which obviously were outlined in the IEP, those services were necessary for the student to access her education. So the order by the hearing officer was to grant the stay put, which essentially meant that the district had to provide in-person services: the speech, the OT, the vision services, the nursing services. And the judge went on to further clarify that those services can be done by a non-public agency. It didn't have to be a district employee. If they couldn't have one available to do that, they could go privately and hire an agency, a private agency that's certified by the state to provide those services. And they also said it didn't have to be done at school. If schools are closed, understand, not a problem. They could be done at some alternative location or even in the home, but they did have to be done according to the stay put order. So the takeaway is, there's really no excuse from providing in-person services when they're required under the student's IEP. So in conclusion, let me just mention a few factors that I think will help kind of guide you through this process. As I mentioned in the previous webinar, not every student is going to be entitled to compensatory services. Not every student's even going to need compensatory services, because sometimes, the students were able to gain an educational benefit even through distance learning. However, there are students that had more intensive needs maybe that really struggled through the virtual learning. They just couldn't access it and didn't have the tools or the accommodations available so they could access their education and gain a benefit. So the first thing you want to do, if you haven't already had an IEP since school started, is to call one. And you can do this by simply making a written request for an IEP. I always recommend that you tape record each IEP meeting. If things go great, perfect, there's no problem. The nice thing about tape recording an IEP meeting is you don't have to take scrupulous notes. You can just listen, participate. The tape recorder is going to do that for you. And it tends to have a much more complete record than what's written on the IEP. There's a lot of discussions that don't really get to be part of the written aspect of the IEP, so that's another good reason. And if you ever get into a dispute, it might be really important to have all of that information that was discussed and the responses of the district, etc., that's included in the IEP. What you need to do is just simply give a written notice that you're going to record. Do it at least 24 hours before the meeting. It's your legal right. You don't even need permission. And most of the time, the school will just forget the tape recorder's even there. It's not a problem, and it just is good record keeping. When you have this IEP meeting, talk about the data that you may have kept during the summer, during the COVID period. For example, your son or daughter, were they able to access the education? What was the duration of the service? How many minutes of academics or speech did they get per day or per week? And if you have any work samples, or you're able to, show how your student progressed or regressed during this time period, that's really important, because you want to try to show where your student is currently functioning. And to the degree that your student wasn't able to access his or her education or make a benefit, or maybe even regressed during that COVID time period, is going to be an important issue for compensatory education. Discuss your child's learning loss during this period, if there was one. Try to quantify that. Talk about what was on the IEP that the child should have gotten but didn't get in the distance learning program. So you can kind of compare what's in the IEP and what they actually received during the distance learning program. So discuss compensatory education. As I mentioned before, the CDE and OSERS all talked about this discussion with the IEP team once school resumed. They expected that many children would regress or not progress, and this is an issue that had to be dealt with, that the school district had to address in an individualized manner what that child's learning loss might be. So it's not across the board, it's not, oh, everybody suffered, so you're all in the same boat. No, an individualized determination for your particular son or daughter, that particular child, needs to be made to look at their learning loss during this time period. And how are they going to make up for that? If it's academics, can they provide some after-school tutoring, or tutoring during breaks? If it's speech language, same thing. Can they provide some extra speech language after school or during breaks? If they can't do it with their own staff, then hire a private provider to help make up those services. And the last point I would make is also just consider additional services your child may need as a result of the closure. So, if they regressed in speech language or in academics or in behavior, then maybe this new IEP should address that, not only in the sense of compensatory services, but also just in the sense of your child might need more help after, the closure to adequately be educated or receive an appropriate education than they would have needed otherwise or before the closure. So that's another thing to keep in mind, is the level of service that your child had on their IEP before the closure may not be the same as after the closure. Your child may need additional services so that they can catch up from where they were before. So it could be a combination of compensatory services, but also possibly even more services on their IEP than what they would have received otherwise. Well, I want to thank you for attending this webinar, and I hope it was helpful. Plan to do updates in the future as we get a little more information about compensatory education and distance learning, any changes in the law. This is a very fluid process, and so we're going to try to help you navigate through this process. We're learning as well as time goes on, so we're certainly going to try to keep you informed of all the important changes that occur in the law. Again, thank you for watching this webinar. Have a great day.